The Supreme Court considers this morning whether businesses must accommodate the needs of pregnant employees. This appeal started with a UPS worker whose doctor told her not to lift heavy boxes. Jan Crawford is outside the court with a case that could affect millions. Jan, good morning.
Well, good morning. So most working women who are pregnant expect to keep working throughout their pregnancy. But what if they can no longer do what their job requires? That's what happened with Peggy Young. She was then a driver with UPS when she became pregnant and was placed on unpaid leave.
I just wanted to work, keep my health benefits, keep my pension money, keep my wage, help support my family.
Peggy Young was a driver for UPS. But in 2006, when she got pregnant, her doctor told her not to lift more than 20 pounds.
Once I got the note, I took it into the health nurse, and she basically said, we don't provide light duty for off-work incidents. Basically, you can't work while you're pregnant.
UPS put her on unpaid leave, leaving Young without salary and health benefits for 7 months.
A woman should never have to decide between starting a family or supporting her family.
Young hired Virginia lawyer Sharon Gustafson and sued, arguing the 1978 Pregnancy Discrimination Act required the company to do more to accommodate her. She lost unanimously in the lower courts, which said UPS did not discriminate. UPS said it was following the law, but it recently voluntarily changed its policy to offer more accommodations for pregnant women, a move the company notes is actually ahead of many companies and government agencies. That's why advocates are looking to the Supreme Court, hoping it requires other companies to offer similar arrangements.
Women who are in Peggy Young's situation will find themselves sometimes faced with a choice between their paycheck and their pregnancy, and that's something we don't want women to have to decide between.
Carrie Severino is representing 23 anti-abortion groups siding with Young, forming an unusual coalition with women's rights organizations like Marsha Greenberger's.
What it speaks to is fundamental fairness, a fundamental recognition that women do not lose rights when they become pregnant.
Peggy Young says she's taking a stand for the next generation.
I don't want either of my daughters to have to experience this or go through this. And not just my daughters, all women. Women should not have to make that decision.
Now, Young and the women's groups obviously are hoping the court will rule in their favor, but if it doesn't, they say Congress has got to step in here, change the law, and fix this problem. Nora?
Jan, do you have a sense of how you think some of these justices are leaning?
You know, I really don't, Nora, and that's why I'm so excited about this argument, because I think we will get a sense from the questions which direction the court may be inclined to rule. But if they do rule against Young, I mean, Congress can just step in here and fix it by changing the law.
A landmark decision indeed. I expect a very, very interesting case. Thank you so much, Jan.